$218,330.
Oh, you made something of this. Like how you put that
Okay,
in.
so I have a bill from the bank of $218,530. I need $219,000.
And look, the deed in your filing cabinet has your name on it. But there's a legal claim on that property that existed before you bought it, survived your closing date, outlasted your mortgage payoff, and will never, not once, go away. And even after the Supreme Court stepped in, more than a dozen states still have laws on the books, loopholes, shadow procedures, workarounds that let them act on that claim in ways that can cost you everything. Here's what I mean. A 94-year-old woman named Geraldine Tyler owned a condo in Minneapolis. Paid for, her name on the deed. She owed $2,300 in back property taxes. By the time penalties and interest piled up, the county said she owed $15,000. So they seized her condo, sold it for $40,000, and kept every dollar, including the $25,000 of her equity above the debt. That went to the Supreme Court in 2023. 9 justices, unanimous. They ruled the county stole from her. Chief Justice Roberts wrote, "The taxpayer must render unto Caesar what is Caesar's, but no more." So the good guys won that one. Your equity has constitutional protection. That's real. That matters. But more than a dozen states still have the laws, or close enough to them, that allowed Geraldine's situation. And they haven't fixed them.
And the problem across the country are property taxes. Property taxes really make it unpleasant to own a home, and they've been rising quite substantially lately.
And there's a second case at the Supreme Court right now. Oral arguments were held just on February 25th that will determine whether just compensation means fair market value or whatever a government-controlled fire sale auction happens to bring in. That distinction alone could cost a homeowner 6 figures, easily. A decision is expected by late June, early July, and this story, it's just not getting nearly the mainstream attention it should. So we need to talk about both, because together they tell you exactly how exposed you are and what you can still do about it. Let me introduce you to the players here, because this is not a story about government incompetence. It's a story about incentives. Player 1 is your county assessor. What they want is revenue. Property taxes fund everything local: schools, fire, police, the whole apparatus. When budgets get tight, the assessor has one lever that they can pull without a public vote. Reassess your home upward. Your tax bill, it goes up. You didn't get a raise, and it doesn't matter. To them, your paid off house is a dry well they need to pump harder. Player 2, and this one may catch you off guard: Wall Street. In many parts of the country, when you fall behind on property taxes, the county doesn't have to wait to collect. They auction the right to collect your debt to a private investor. That investor then charges you interest, not 8%, not 12%, in some states up to 36% annually, by statute, guaranteed by law. And this isn't mom and pop stuff. No, the industry's own trade group, the National Tax Lien Association, reports that roughly 80% of tax lien certificates go to institutional buyers. And we're talking about hedge funds, private equity, and major banks. Public delinquency lists, they make these properties really easy to find, and a paid off home with no mortgage is the cleanest target on the list. So if your name is on that deed, you're on that list. HideMyEquity.com is where I scrubbed mine. A Florida retiree named Gladys Walker fell behind on her taxes. The debt, $768.25. Bank of America and a hedge fund called Fortress Investment Group, fresh off their taxpayer-funded bailout, bid over 8,000 times for the right to collect her $768.25 debt. Then Bank of America bundled $301 million in similar liens into securities and sold them to institutional investors. Your neighbor's tax debt, packaged into a Wall Street bond, tracked by a fund manager with no community relationship, no discretion, and no fiduciary obligation to collect or foreclose. They didn't even try to hide it. I mean, they filed it with Moody's. And while Wall Street is working one end of this, your county assessor is working the other. They don't call it a tax increase. They call it an assessed value adjustment. Assessed value adjustment. I mean, that phrase is doing a lot of heavy lifting. What it actually means is we decided your home is worth more this year, so you owe us more money. And this never ends. And you've got 30 to 90 days to appeal it before the window closes. a right we are not required to prominently advertise. This assessed value adjustment, it's like your landlord calling a rent increase a habitation optimization fee. It's a tax hike in a blazer. Here's your first active defense move though. Do this today. Go to your county assessor's website. Google your county name plus property tax assessment. Look up your property. Find the assessed value. You can do all of this in one spot at fightmyassessment.com, by the way. But then go to Zillow, open that up, or Redfin, and look up your address. If the county's number is above market value, you're legally overpaying, and you can appeal. Many counties right now are in or near appeal season, so check yours today. In many places, the process, it's very inexpensive. In most cases, it's free to start. And most homeowners, they never do it because nobody told them that they could. And while you're at it, call the assessor and ask, am I receiving every senior and homestead exemption I'm entitled to? And veterans, see what special exemptions you may be entitled to. Many counties have exemptions that cap how much your taxes can rise year over year. If you haven't filed for those, you're leaving money on the table that the county is happy to keep. Here's the scale of what we're talking about. American homeowners collectively hold roughly $34 trillion in equity. That number comes from the Federal Reserve. And Washington is currently carrying nearly $39 trillion in debt. Now, those are not identical numbers, but they're in the same conversation. And I'll tell you what I think that means in a minute. But first, here's what the machinery that already exists can do to you right now. A county in Michigan foreclosed on a property and sold it for $24,500. The original unpaid tax, $8.41. Yeah, you can't make that one up. Kevin Fair in Nebraska lost his home over a debt of less than $600. The Pung family in Michigan had their home seized, assessed by the county itself at $194,400, auctioned for $76,008. And then it was immediately flipped by the buyer for $195,000. The family got the difference between the auction price and their debt, not fair market value. Whatever the fire sale auction happened to bring in, minus what they owed, that's what they got. That's the ruling we're waiting for from the Supreme Court this June or July. And in Michigan, county emails from another seizure case, a $3 million lakefront mansion, described the acquisition as tickled pink. That is someone describing the seizure of an elderly person's home the way you described finding a front row parking spot at the mall. And there's a multi-billion-dollar industry of hedge funds, private equity firms, and Wall Street banks that have turned your tax delinquency into a financial product, with the trade association and lobbyists in dozens of state capitals. So it would be a good idea to pivot right now, because here's what the smartest homeowners actually do about this. And look, remember, I'm just a guy who buys houses for a living. I've never passed a bar exam, but I've read enough deed records and forfeiture filings to tell you many sophisticated owners use trusts, entities, and estate planning instead of leaving everything in their personal name. You see, when your home sits in an LLC or a trust, the predators running algorithms on public delinquency lists, they see an entity with an attorney of record, not a vulnerable individual to isolate. The math, you see, it breaks down for a speculator trying to spend $15,000 in legal fees to collect a $3,000 debt on a property that has procedural complexity attached. When your home is in your name with no mortgage, you see, there's no lender, there's no escrow account, there's no attorney of record, none of the few automated backstops that used to be watching. You're the only one watching. And the delinquency list is public. And I'll say more about that in just a minute, because it's the part Dave Ramsey's people are not going to like. You see, here's where I have to admit what I can and can't prove. Here's my take. I can't show you a secret government document that says, seize the $34 trillion in home equity. What I can show you is that the tools to access it, property taxes, forfeiture, eminent domain, are already installed. They're already constitutional within limits and are being actively stress tested in courts right now. The Tyler case in 2023, the Pung case with a decision due in a few months. Those aren't random. Those are the system finding its legal ceiling. And that process is still underway. I mean, you decide what that pattern means. If you've had a nagging feeling that own it free and clear and you're safe didn't quite add up, you were right. And you've been around long enough to trust that instinct. You've watched enough economic cycles. You've seen enough political promises that didn't survive contact with the balance sheet. You don't need a finance degree to notice that your fixed income bought a lot more stability 10 years ago than it does today. And no one is asking this out loud, so I will. If the Supreme Court already ruled in 2023 that home equity theft is unconstitutional, why do more than a dozen states still have the statutes, the loopholes, or the shadow procedures? And more importantly, is your state one of them? You know, you woke up today in a world that's been working against you for years, but now you've got the playbook. And let's talk about now the Ramsey advice specifically, because this matters for your equity position right now. Conventional wisdom says, pay off your mortgage as fast as possible. Own it free and clear. That's the ultimate financial safety, not to mention a really good night's sleep. For a debt-heavy younger household, correct, that's a good move. It's important. Do it if you can. For the over 55 equity-rich homeowner on a fixed or declining income, that advice quietly pulled the one safety net you didn't know was there. AARP filed a formal brief at the Supreme Court in the current case. It says, and I'm quoting directly, that older homeowners are especially impacted by tax foreclosure because they often rely on home equity as a safety net. Older adults are more vulnerable to tax delinquency because they may rely on fixed incomes or have large medical expenses. When you have a mortgage, your lender watches your property tax payments through escrow. The bank doesn't want the county to foreclose on their collateral, so they pay the taxes if you fall behind and then just bill you later. But that's not kindness. That's the bank protecting its own investment, and it was indirectly protecting yours at the same time. When you own free and clear, there's no lender, no escrow, no monitoring. One medical crisis, one missed notice, one chaotic 6 months, and the clock starts. And in many states, a private investor might be holding your lien before you even know you're delinquent. A poorly structured trust can make it much easier for someone to step in during a health event without a court-ordered conservatorship, without a delay, without missing a single notice. The paid-off home without legal structure is the most exposed asset on your block. The paid-off home inside a fortress of proper ownership and protection, that's solvency. That's a war chest you can actually defend. Now, I'm not your attorney or your CPA, and every state is different, every situation is different. What I'm laying out is a framework for thinking, not a prescription. Here's what I'd be doing, and there are 3 levels to this. Level 1, do this in the next 15 minutes. Go to homeequitytheft.org. Check your state. Find out whether you're in a state that's reformed its laws after Tyler or one that still has the loopholes. Then pull your assessment notice, compare it to Zillow, appeal it if the county's number is higher, and ask about senior and homestead exemptions while you're at it. That call, it costs you nothing. Now level 2, for homeowners with $200,000 or more in equity. Look at deed protection and proper ownership structuring. The framework, don't leave a paid off home unmanaged. For many families, the starting point is a revocable living trust, a clean estate plan, a backup notice system, and someone besides you watching the tax mail. Entity structuring, LLCs, land trusts, that can matter too, but that gets state-specific fast. HideMyEquity.com is where you start that conversation. Now, level 3, legal protection before you need it. Geraldine Tyler had Pacific Legal Foundation. The Pung family, they had attorneys. Most homeowners have nothing standing by until the certified letter has already arrived. BullyProofMyLife.com is where you can fix that. You see, you're the type of person who reads the document, checks the number, asks the question your financial advisor forgot to ask. That's not paranoia. That's what protecting what you've built actually looks like. And here's the sentence I want you to take to the dinner table tonight. The advice that was supposed to protect you, pay off your mortgage, own it free and clear, quietly exposes you in a way Dave Ramsey never mentioned. Meaning there's nothing left standing between your home and a system that's been industrializing the collection of your property taxes for 30 years. And if you think the claims on your home are something, wait until I show you who's already mapped what's inside it. I'm talking about the surveillance that's been running on your property without your knowledge. And it's not the county doing it. I'll show you who in this video right here. Click here and I'll see you over there, all right? God loves you and so do I. Take care.